Good morning, everyone. I'd like to start, if I may, with an audience poll. We did this last year, but hopefully it will work this time. Here we are. It's the blue bus. Oh, no, we are not. Do we have the blue bus question? Yes. Now, some of you may already be familiar with the blue bus problem. Others may not. But if you read the text on the screen, it's briefly described. You were asked to assume that the claimant is negligently run down by a blue bus. That's all she knows about it. The bus was blue. At the trial, the only evidence put forward is that the blue bus is that the defendant company operates 80%, maybe 80, 85%, doesn't matter, of all the blue buses in town. And the question is, if that is the only evidence adduced at the trial, is it enough to prove the claimant's case to the civil standard of proof? And when answering the question, you're asked to ignore questions about the fact that inference might be drawn from no other evidence being adduced. Just concentrate on the content of the evidence that you've got. So I'm hoping that you're going to be able to answer with your what you think about the answer there, yes or no. Someone may need to explain how this is done. I think you have to scan the code, I think, or log on, but I'm hoping some will be able to vote. Oh, look, already the no's are leading the way, but I'll be coming back to this, of course, later in my talk, but well, that's probably enough of a sample. It looks about two-thirds. The no's have it, two-thirds for no, one-third for yes. I'll be coming back to that later. Well, thank you for having me back again this year. Those of you who were here last year, as was just mentioned, may recall that I spoke then about whether you can tell from the demeanour of a witness whether the witness is lying or telling the truth. And I've come back here under false pretenses because the original intention was that I would continue with the topic of witness testimony, and there'll be a part 2 on that. But a year is a long time in law, as they say, and when I started to think about this talk, my interest fastened on another topic. Now, the civil standard of proof may not immediately strike all of you as a particularly stimulating topic, but my hope over the next few minutes is to convince you that it is, and that it gives rise to some intriguing questions about the nature of probability and proof. And one person, at least, I know I will not need to convince is your former chair, Sir Nicholas Mostyn. Not all of you may be familiar with his paper, co-written with a statistician, published in the International Journal of Evidence and Proof, called Probability Reasoning in Judicial Fact-Finding. But those of you not familiar with it already may not be surprised to learn that it contains a characteristically robust defence of the reasoning in one of his own judgments against criticisms made by the Court of Appeal. I intend to weigh into that debate with some thoughts of my own about it. But before that, let me begin with a little legal history. Now, a lot has been written about the history of the criminal standard of proof, traditionally defined as proof beyond reasonable doubt. The civil standard of proof has not received the same attention. In fact, there appears to be only one study of its history, which is an article published in the Florida Law Review in 2015. According to that study, the earliest clear recorded statement of the civil standard of proof is in a work published in 1768. The author, Edward Wynne, according to the Oxford Dictionary of National Biography, was a gentleman scholar who qualified as a barrister, but thanks to his large fortune, did not need to pursue an active career in the law. His dialogues concerning the law and constitution of England sought to explain principles of law to a lay audience. Wynne wrote that where evidence is produced on both sides, the verdict is given for the plaintiff or defendant according to the superior weight of evidence. Similar language of superior weight or preponderance of evidence was used in several treatises on the law of evidence published in the early 19th century to describe the civil standard of proof. It was usually contrasted with the criminal standard. But what explains the difference? Well, Blackstone, in his commentaries, famously explained the justification for the criminal standard of proof by saying that it is better that 10 guilty persons escape than that one innocent suffer. So in other words, to convict and punish an innocent person for a crime that he or she did not commit is a grave injustice, and there's no comparable injustice involved where a guilty person is acquitted. So for that reason, the law should err on the side of acquittal by requiring a high standard of proof in criminal cases. Civil proceedings are different. Generally, at least, in a civil case, there's no reason to tilt the scales in favour of one party or the other. Indeed, it would be unjust to do so. Take a money claim, which turns on an issue of fact. If the claimant's factual case is true, the claimant has a legal right to be paid the money. If not, the defendant has a legal right to keep it. The parties' rights are symmetrical. Hence, the principle of equal justice requires that the risk of error in the fact-finding process should be evenly distributed and not biased in favour of one or other party. The language of preponderance or greater weight of evidence is still commonly used to describe the civil standard of proof in the United States. It is still occasionally used in this country. But over the course of the 19th century, another formulation of the civil standard, the balance of probabilities, emerged and gradually gained currency. No one ever seems to have discussed which formula is preferable or why, but gradually the balance of probabilities became, at least by the 1920s, the dominant formula. And in the last 50 years, there's been another development. The balance of probabilities is sometimes now expressed numerically. The first example of this that I found is in a case called Davies and Taylor in 1974, where Lord Simon of Glaisdale said, "Beneath the legal concept of probability lies the mathematical theory of probability. Only occasionally does this break surface, apart from the concept of proof on a balance of probabilities, which can be restated as the burden of showing odds of at least 51 to 49 that such and such has taken place or will do so." In recent years, statements of this kind have become increasingly common. Here is a typical example from a judgment given in the High Court last year. I reach my conclusion on the basis of simple probability, that is, that it's more likely than not, more than 50% likely that such and such a thing happened. Many more examples could be given. The current edition of Financial Remedies Practice has gone further. It assigns percentage probabilities to the requirements which need to be satisfied on various types of injunction application. For example, the real prospect of success required by the American cyanamide test is given what is described as an approximate numerical probability of greater than 25%. What accounts for this trend of expressing the civil standard of proof mathematically? I see it as a reflection of the extent to which the concept of probability, understood mathematically, has pervaded modern thought, not only in the natural, social, and medical sciences, but in everyday life. To give just two examples, It's now the norm for weather forecasts to express the prospect that it will rain as a percentage probability. And as a cricket match progresses, a prediction of the outcome expressed as a percentage probability is now regularly displayed on televised broadcasts. Thinking in such terms has become more and more natural. For many people, it is now intuitive to express the idea that something's more likely than not by saying that it has a greater than 50% probability. There are cases where judges have expressed as a percentage not just the standard of proof on the balance of probabilities, but their view of the probability that a particular event occurred. I'm not talking about cases here where statistical evidence is relied on. My interest is in cases where there's no statistical basis for such statements. Now, for reasons of time, I'll take just one example. It's a judgment of Mr. Justice Mostyn, as he then was, in Re D, a child. Now, the fact in issue in that case was whether the mother of a baby born with multiple ailments and diseases and dependent on a constant supply of oxygen to survive had deliberately switched off her child's oxygen supply while staying in the hospital overnight. There were agreed to be three possibilities. One, the oxygen supply was not in fact turned off, and a nurse was mistaken in thinking that it had been. Two, a student nurse had accidentally switched off the oxygen tap when asked to check that the machine was working. Or three, the oxygen tap was deliberately turned off by the mother. A counsel for the local authority invited the judge, first of all, to find as a fact on the balance of probability that the tap was indeed turned off, and then, proceeding on that basis, to decide on the balance of probabilities whether that was done deliberately by the mother or accidentally by the student nurse. Mr. Justice Mostyn rejected that approach. He found on what he called the barest balance of probability that the tap was indeed turned off. But he pointed out that if he were to treat that as a fact and then decide whether the nurse or the mother was responsible, he could reach an illogical and unjust result. To illustrate this point, he put the probability that the tap was indeed turned off at 55%. And if required then to choose between the two possible explanations for the tap being turned off, he assigned probabilities of 40% to a deliberate act by the mother and 60% to a mistake by the nurse. On the approach suggested to him, that would have led to a finding that the student nurse had probably turned off the oxygen supply. But Mr. Justice Mostyn pointed out that on his illustrative figures, the true probability of that event, that the nurse had turned off the supply, would be 60% of 55%. In other words, 33%, and therefore less probable than not. And so it was wrong to conclude that that was the probable cause of the incident. Now, there was no appeal in that case, but in two other cases, this type of reasoning has been criticised by the Court of Appeal. The first case is called Milton Keynes Borough Council and Nulty, decided in 2013. In fact, I think before Mr. Justice Mostyn's case, but it wasn't cited to him on that occasion. And in Nulty, Lord Justice Toulson, who gave the lead judgment, rejected a submission that the court should ascribe percentage probabilities to different possible explanations for a fire, and then see whether one had a probability greater than 50%. He described such an approach as, quote, intrinsically unsound, and he said, the chances of something happening in the future may be expressed in terms of percentage. Epidemiological evidence may enable doctors to say that on average smokers increase their risk of lung cancer by X%. But you cannot properly say that there is a 25% chance that something has happened. Either it has or it has not. And Lord Justice Toulson also said that to express the probability of some event having happened in percentage terms is, quote, illusory. The second case called Re-A Children, is one I alluded to in passing at the start of this talk. There, the Court of Appeal adopted Lord Justice Toulson's remarks. They referred to a judgment of Mr. Justice Mostyn, where he had used probabilistic reasoning, and expressed the greatest respect for the erudition of Mr. Justice Mostyn, always one of the most damning judicial comments, that, the greatest respect, before saying that it was inappropriate. And they described the use of percentage probabilities as, quote, a pseudo-mathematical approach to the burden of proof. Pseudo-mathematical. Not very kind description. Now, the Court of Appeal in those two cases made a striking claim. They claimed that it is intrinsically unsound or pseudo-mathematical to ascribe percentage probabilities to past events. That claim is, I think, easy to refute. Suppose that I toss two coins, wait for them to land, and then, without letting you see how they have landed, I ask you, what is the probability that they both landed heads, two heads? I don't imagine that you will have any trouble in answering that it is 25%. But it would, I think, be too quick to leave the matter there, and that is because the distinction drawn by Lord Justice Toulson between the probabilities of future events and past events raises some fundamental questions about the nature of probability which are worth exploring. Nowadays, any basic course on mathematics includes a section on probability. The mathematical rules of probability are well known. They can be expressed as a set of axioms from which conclusions logically follow. In themselves, they present no conceptual difficulty. But to adapt the words of Lord Simon, beneath the mathematical theory of probability lies the philosophical concept of probability. What are probabilities? Well, if you read any of the literature discussing this question, as rather sadly you may think I spent a fair bit of this summer doing, you soon realize that there is more than one concept or conception of probability. In fact, numerous different interpretations of probability have been put forward. The subject is further complicated by the fact that there's no agreement about how to classify these different theories, nor indeed about how many theories there are. Most introductions identify 2 or 3 theories, but one book I came across as many as 11 different theories. For simplicity, I'm going to adopt the classification which I have found the clearest and most useful. It is that used by the late Hugh Mellor, a philosopher whose lectures I attended at Cambridge many years ago, and whose excellent book, Probability: A Philosophical Introduction, is the best of the books that I have read on the subject. Now, Mellor distinguishes 3 different conceptions or types of probability. The first he calls physical probabilities or chances. Examples are the chance of winning a lottery, or of living to be 100, or of contracting a disease if exposed to it. When the outcome's a bad one, like contracting a disease, we often refer to chances as risks. This is the conception of probability that Lord Justice Toulson evidently had in mind. Statements about chances are inherently forward-looking. They're either statements about what will happen or may happen in the future, or they're counterfactual statements about what would have happened if something had happened differently in the past. Chances are important in many areas of life. To take just one example, the whole business of insurance is based on estimating chances. Another way of thinking about probabilities is as degrees of subjective belief. Mellor calls these credences. Credences are measures of how strongly we believe propositions, such as that it will rain next week, or that England will win the Ashes, or that Lee Harvey Oswald did not act alone when he shot President Kennedy. The beliefs may relate either to the future or to the past, but there's no necessary connection between the strength of my belief that something has happened or will happen, and any facts about the world. And 2 individuals can assign different subjective probabilities to the same proposition, given the same evidence. The first person to develop a subjective theory of probability systematically was the brilliant philosopher, mathematician, and economist Frank Ramsey, who made major contributions to all those fields before he died at the age of only 26 in 1930. He developed the idea that degrees of belief can be quantified by seeing what odds someone is prepared to accept in a bet on a particular outcome. So if I'm prepared, say, to bet £4 that Manchester City will win the Premier League this season, in return for winning £6 and getting my stake back, that's £10 in all, if that happens, then that could be interpreted as my ascribing a subjective probability of at least 40% to that occurrence. Then the third way of understanding probability is different again. This is as a measure of the extent to which a given evidence supports a proposition. Probabilities of this type are often referred to as epistemic probabilities, after the Greek word for knowledge, because they're always relative to a given state of knowledge. So going back to my two coins, given your knowledge, which includes the knowledge of the general properties of coins, they have two faces, heads on one side, tails on the other, and so forth, but not sight of how these particular coins landed, the probability, given that knowledge, that they both landed heads is 25%. But suppose you then see that one of the coins has landed heads, but you can't see the other. Well, then the probability, based on that knowledge, that they both landed heads is 50%. And for me, who has seen that they both did in fact land heads, the probability is 100%, a certainty. One way of thinking about this kind of probability is as degrees of justified belief. In principle, the more strongly the evidence supports a particular hypothesis, the greater the degree of belief in that hypothesis which the evidence justifies. A pioneer of this epistemic conception of probability was one of Ramsey's teachers at Cambridge, John Maynard Keynes, who, before the work in economics for which he's best known, wrote an important treatise on probability. The distinction between these three different kinds of probability sheds light on the role of probability in English law. Courts have no difficulty in principle in estimating chances, even when there's no scientific or statistical basis for doing so. In particular, courts regularly discount awards of damages by ascribing a percentage to the chance that something will occur or would have occurred but for the defendant's conduct. An example is discounting a financial award in divorce proceedings by an estimate of the chance that a person will remarry. When it comes to deciding what happened in the past, the law takes a different approach. Whether or not a past event happened is not a matter of probability in the sense of chance. Once an event has or has not happened, chance no longer comes into it. But we can and do properly say that it's more probable than not that an event occurred. The conception of probability which best explains such statements is the epistemic conception. Chances are not apposite, nor are credences. We expect courts to reach conclusions which are not just statements of the judge's degree of subjective belief, but are justified by evidence. The epistemic conception of probability fulfills this role. It provides a method of reasoning from given evidence to a finding of fact by measuring the extent to which that evidence supports or justifies belief in such a finding. Lord Justice Toulson was therefore right, I suggest, to distinguish between chances and matters of past fact, and to say that whether a past event happened is not a matter of chance. But he was wrong to suggest that it's intrinsically unsound to speak about the probability of a past event. It makes perfectly good sense to do so, provided we're clear that we're talking about epistemic probabilities and not about chances. That's not to say that there is generally any rational basis for ascribing a number to the probability on given evidence that a particular event happened. Situations in which such quantification is possible are rare. Our ordinary judgments are much more broad brush. We may have reasonable grounds for believing that a certain event is extremely unlikely to have happened, or fairly unlikely to have happened, and so on. We can also often rationally compare or rank the probability of competing claims, so as to conclude that on given evidence, one claim about what happened is more probable, or much more probable, than another. But in most circumstances, Lord Justice Toulson was surely right when he said that to express the probability of some event having happened in percentage terms is illusory, by which I take him to have meant that it gives a misleading appearance of precision to an assessment that is necessarily imprecise. A statement such as the probability that the oxygen tap was turned off is 55% appears scientific, but if probed, it will inevitably turn out to be in large part an expression of a purely subjective degree of belief, since there's no system of measurement by which a numerical value can be given to the degree to which the evidence supports such a belief. I do not suppose for a moment that Mr. Justice Mostyn in Re Dia Child thought otherwise. When he ascribed percentages to the three possible scenarios in that case, he said that he was giving figures only for the sake of example. There's nothing intrinsically unsound about that. Furthermore, the point that he was using numbers to illustrate is a good one. But assigning numbers to probabilities which are incapable of being represented numerically is liable to give a wrong impression of the nature of the fact-finding process, and for that reason, it seems to me preferable to avoid it. I turn from the standard of proof to the burden of proof in civil cases. Why do we have a burden of proof? If, as I've argued, in civil cases the principle of equal justice generally requires the risk of error to be distributed evenly between the parties, how can it be right to bias the scales, even if only slightly, in favour of either side? An answer sometimes given is to cater for a situation where the probabilities are equally balanced. It's said that as a court does not have the option of declining to decide a case, the burden of proof is needed to operate as a tiebreaker in this situation. I would accept that this is a theoretical reason for placing a burden of proof on one party or the other, but not that it is a practical one. I find it hard to imagine reaching a conclusion that the probability that a statement of past fact is true and the probability that it is false are precisely equal. That would require a very finely calibrated assessment of probability. And as with expressing probabilities as numbers, it is surely unrealistic to suppose that the strength of evidence is capable of being measured with that sort of precision. I've come across one case, though only one case, where an equal balance of probability was given as a reason for resorting to the burden of proof. Morris and London Iron and Steel Co. Limited was an employment claim for unfair dismissal, and the issue was whether the claimant employee had been dismissed by her employer, or whether, as the employer alleged, she had voluntarily resigned. The burden of proof was on the employee to prove that she'd been dismissed, and the tribunal held that she'd not discharged that burden, so the claim failed. In giving their reasons, the tribunal said this. They said, after considering all the evidence and observing the demeanour of the witnesses, it's too early for them to have attended my talk last year, we find that the probabilities are equally balanced. Now, taken at face value, that looks like a rare, possibly even unique, instance of a fact-finding tribunal deciding that the probability that an alleged event occurred was precisely equal to the probability that it did not occur. But I doubt that that is what the tribunal really meant. In the next sentence, immediately after the words I've quoted, they said, "We do not feel able to make a finding of fact as to which version of events is to be preferred." Now, that's a different reason for their decision. A conclusion that the tribunal does not feel able to make a finding as to which version of events is more probable is not the same as making a finding that the probabilities of the two versions are exactly equal. A positive finding of equal probability would, I've suggested, require a degree of precision in the evaluation of evidence, which is unrealistic. A conclusion that the evidence does not permit a positive finding one way or the other hand, is an understandable response in cases where, for one or another reason, the evidence does not provide an adequate basis on which to rest a conclusion, either that a fact in issue is true or that it is false. In Morris, the Court of Appeal upheld the tribunal's approach. Lord Justice May, who gave the lead judgment, said that judges should, so far as practicable, and insofar as it's in accordance with their conscientious duty, make findings of fact. But he also said, in the exceptional case, however, a judge conscientiously seeking to decide the matter before him may be forced to say, "I just do not know." Indeed, to say anything else might be a breach of his judicial duty. And that, in the Court of Appeal's view, was where the Employment Tribunal had ended up, with the result that they were entitled to fall back on the burden of proof. And there's a line of later decisions of the Court of Appeal following and endorsing that approach. I was intending to look in some detail at the leading case on this particular point, called the Poppy M, sometimes referred to as the Yellow Submarine case. For reasons of time, however, and as I don't want to encroach more than the 5 minutes I've been allowed on the time of the next speaker, I shall have to pass over the interesting facts of that case and giving my own theory about the cause of the sinking, and go straight to Lord Brandon's statement. Mr. Justice Bingham was the judge. Lord Brandon in the House of Lords said that on this occasion Homer had nodded, and I was going to point out that most judges would be very happy if they're going to be reversed with that particular description of what went wrong. But here is Lord Brandon in the House of Lords. No judge likes to decide cases on the burden of proof if he can legitimately avoid having to do so. There are cases, however, in which, owing to the unsatisfactory state of the evidence or otherwise, deciding on the burden of proof is the only just course for him to take. It is the only just course to take because we do not want judges to make findings of fact which are not rationally supported by evidence. If the evidence is inadequate to justify a decision one way or the other, then rather than make a decision for which there are no reasonable grounds, it's better to fall back on a default rule which allocates the risk of such an outcome in advance to one or other party. That, as I see it, is the primary function of the rules which allocate the burden of proof. Those rules are rules of substantive law which identify the essential elements of a claim or defence, and hence the party in whose favour a fact in issue must be found if the claim or defence is to succeed. It's an efficient principle and a just one to place on the party which needs a finding in its favour to succeed on an issue the onus of ensuring that there's enough evidence, and evidence of sufficient quality, placed before the tribunal to enable the tribunal rationally to make a finding. If such evidence is lacking, the issue will be decided automatically by default against the party which bears this burden of proof. If we focus exclusively on probabilities, this point is liable to be overlooked. To explain this feature of proof, we need another concept. The first person to identify this concept clearly may have been Keynes. In his treatise on probability, he wrote, "As the relevant evidence at our disposal increases, the magnitude of the probability of the argument may either decrease or increase according as the new knowledge strengthens unfavourable or favourable evidence. But something seems to have increased in either case. We have a more substantial basis upon which to rest our conclusion. And I will refer to this feature as the adequacy of the evidence on which the assessment of probability is based. Sometimes, where the evidence is inadequate, it may simply not be possible to judge the likelihood that something happened reliably enough to reach a rational conclusion one way or the other on the balance of probabilities. To illustrate this point further, imagine a jar in which I have placed 100 marbles. You are told that the marbles in the jar are all either black or white, but not how many there are of each colour. Now suppose that 20 marbles are taken at random from the jar. 13 are black, 7 are white. And you're asked to determine whether on the balance of probabilities I've placed more black marbles than white marbles in the jar. If you had to reach a conclusion on that limited information on the balance of probabilities, the only conclusion you could rationally reach would be that the jar probably contains more black marbles than white. Well, now suppose that a much larger sample is taken. 70 marbles are removed. And you find that 40 are black and 30 are white. Now, given this information, the probability that I placed more black marbles than white marbles in the jar is in fact lower than the probability based on the first sample, as the percentage of black marbles in the second larger sample is only around 57%, compared with 65% in the first. Yet there's clearly a more substantial basis on which to rest a conclusion, and you would naturally feel much more confident in inferring that the jar contains more black marbles than white. Now, I believe that this example sheds light on the problem which I posed you at the start of this address, generally known as the blue bus problem, and on which a great deal of ink has been spilt since it was raised first in an article in the Harvard Law Review in 1971. Scholars have been debating this problem for more than 50 years. Most agree, as the majority of you, the audience, did in our poll, that on the hypothetical facts, the claimant has not discharged the burden of proof. But they disagree about why. Many different explanations have been proposed. My suggested explanation relies on the distinction that I have been drawing between the probability of an event on given evidence and the adequacy of that evidence on which the assessment of probability is based. If the only evidence we have is that the defendant operates 80% of the buses in the town, and we're asked whether, given this information, it's more probable than not that the bus which hit the claimant was one of the defendant's buses, then the answer is yes. But it does not follow that this evidence alone is sufficient to discharge the burden of proof. The majority of people would say that it is not. It is not that there's anything wrong with statistical evidence per se, but the evidence adduced is by itself too insubstantial a basis on which to rest a finding that the defendant operated the bus in question. The two main reasons for its inadequacy are, first, that too much relevant information is missing, and second, that the available information is insufficiently specific. To provide an adequate basis for a positive finding, we would need some more and more detailed evidence. For example, evidence about bus routes and timetables from which we could see which company's buses would be expected to have been travelling down the street where the accident happened at the relevant time. On the unsatisfactory state of the evidence assumed to be before the court, the appropriate conclusion may be that the claimant has failed to discharge the burden of proof. So to conclude, there's a tendency to think of the burden and standard of proof as very closely related concepts, and to interpret the standard of proof as specifying the extent or degree to which the burden of proof must be discharged. I suggest that it's more illuminating to view the two concepts as relating to two different dimensions on which evidence must be assessed. The standard of proof concerns the degree of epistemic probability required to justify a factual finding. The burden of proof, on the other hand, concerns the adequacy of the evidence, which forms the basis for this assessment. I've suggested that the rationale for the civil standard of proof is that fairness requires the risk of error in deciding factual issues to be evenly distributed between the parties. The distribution of the risk of error between the parties is not, however, the only relevant consideration in fashioning the rules that govern proof. deciding factual issues by spinning a coin would distribute the risk of error equally between the parties, but it would plainly not be an acceptable basis for judicial decision. As well as the distribution of the risk of error, the extent of the risk of error is also important. We do not expect courts to be infallible, but we expect them to reach factual conclusions which are rationally supported by evidence. Cases where the evidence is so inadequate as to make this task impossible are thankfully rare, but it's in such rare cases that to maintain the court's legitimacy, it is necessary to fall back on the rules which allocate the burden of proof. Thank you all very much for your kind attention.